Naming beneficiaries feels simple, but it's one of the most common places where small choices can have big consequences. When you name beneficiaries, you'll usually see two categories: primary and contingent. Your primary beneficiaries are the people or organizations who receive property first. Contingent beneficiaries step in only if a primary beneficiary can't inherit. For example, if they've passed away before you. Naming contingent beneficiaries helps avoid unintended outcomes, like assets passing through intestacy or to people you don't intend, simply because the first choice wasn't available anymore. You may also notice that you can name individuals or organizations, like charities. Both are valid choices. The key is being clear and specific. Full legal names matter here. If you're naming an organization, accuracy is especially important. A slightly incorrect name can create delays or confusion later, even when your intent was clear. There are a few very common issues we see when beneficiary designations aren't thought through carefully. One example is assuming that everyone will understand what I meant. Courts don't interpret intent, they follow written instructions. Clear choices now help avoid conflict later. This page also matters because beneficiary designations don't exist in isolation. Your will, your powers of attorney, and even accounts outside this package should tell a consistent story. When documents conflict, the results can be surprising. If you're married, you may notice the system assumes a spouse first structure. That's intentional. In many families, a surviving spouse is the primary financial and logistical bridge between generations. That said, every family is different. The important thing is that your selections reflect your current reality, not an old assumption or an outdated plan. Timing matters more than people realize. Divorce, remarriage, estrangement, or the death of a beneficiary can all change how these provisions operate. If this section brings up emotions, that's okay. Estate planning often does. Take a breath, answer honestly, and remember, clarity now is a gift to the people you care about. Once beneficiaries are named clearly and thoughtfully, the rest of the will usually falls into place more easily. And if you find yourself unsure, especially with blended families or changing relationships, that's exactly when a consultation can help.
If you'd like a Nevada attorney to review your documents or your situation, you can schedule a consultation for $250. Using this form and watching this video does not create an attorney-client relationship. This content is educational only.